morning and welcome to Cheche, the show where opinion counts, live on Citizen TV. I'm your host, Udwaka Mimo. The Judiciary has become the latest in a line of institutions to announce its preparations for next year's general elections. We all know how protracted electoral challenges can be, and there are concerns about the Judiciary's ability to fairly adjudicate any disputes arising given a spate of recent scandals. Justice David Maraga, today's guest, is the presiding judge at the Court of Appeal in Kisumu. He is also the chair of the Judiciary's Committee on Elections, the JCE. He's just overseen 3 pieces of work documenting the Judiciary's preparations for next year's polls. A book exploring the many lessons from past elections, a report on past work by the Judiciary on elections, and a strategic plan for the roadmap ahead. As always, we have with us a panel, Mutegi Njau and David Makali. Good morning and welcome to the show.
Thank you.
Judge, take us through the background to the JCE. What necessitated this singular focus on elections and preparing for them?
Thank you, Hudak, for having me in the studio this morning. The Judiciary has had a history of handling election petitions. It is common knowledge that the petitions used to take as long, sometimes as 5 years, the whole term of Parliament. And you will recall that after the 2008 post-election skirmishes, part of the reasons given was that the Judiciary could not be trusted to handle election petitions effectively. Aware of that, of course, the Chief Justice and the Judicial Service Commission decided to establish a committee to prepare the Judiciary, first of all, to deal with the election petitions, more importantly, within the times specified in the Constitution. Election petitions, you know, the presidential election petition has to be filed within 7 days and determined within 14 days after filing. The other petitions, the parliamentary petitions, gubernatorial petitions, and the member of county assembly petitions have to be filed within 28 days and disposed of within 6 months. So the Judiciary had to prepare. You know, those are constitutional imperatives. You don't clear those petitions within that time, you run into a constitutional crisis. So that is what informed the formation of the committee to prepare the Judiciary. The work of the committee was mainly administrative, to see what the judges and magistrates require in the various stations to be able to discharge their duties. So that is really the work of the Judiciary, and of course to also liaise with other stakeholders. We have very many of them, as to how effectively we can serve the Kenyans.
Okay, so you've touched a bit on your mandate.
Yes.
And you say that the JCE came into being because, you know, you had this history of, you know, the Judiciary not quite disposing of electoral petitions in, as per constitutional guidelines. But what did you find when you got there in terms of the legislation, the architecture? Because you chair JCE.
Yes.
But there's some background to this.
Yes.
In 2012, this was the first time we were attempting to align ourselves with the constitutional provisions.
Yes. Well, the first time, immediately after the formation of the committee, the first task that we...
But that was a different committee, JSEP.
Yes, yeah.
The Judiciary
Working Committee on Election Preparation.
Yes.
The very first task we embarked on was to look at the law, the legal framework under which we were going to operate. And we noticed that under the Elections Act, all election petitions were going to be heard by the High Court. At that time, I think we had how many High Court judges? Not as many as we have now. And we realized there was going to be a problem immediately. So what we did was to make recommendations to Parliament, and we are happy that Parliament listened to us, and they amended the Elections Act to devolve jurisdiction to the magistrates' courts to handle election petitions arising from the elections of members of the county assembly. So that took quite a great chunk of the petitions, because we have more magistrates than judges. So that is the first task we carried out.
How is it that I understand there are still pending cases, petitions, even now, like the one of Chris Bishag?
You know, those are residual kind of matters that have gone to the Supreme Court. But the High Court and the Magistrates Court completed the election petitions within the time set in the Constitution. And you know, the Supreme Court is only one court. There are 7 judges, but it's one court. It must have a quorum of 5. So those are the residual kind of matters which are being finalized.
Can it be need, you know, if you are Chris Bishag now waiting for a petition to be done, either the Supreme Court, whoever, did you not foresee that can happen? Because it has happened. You have Chris Bishag waiting for a petition, and the elections are next. Yeah.
Well, that is being addressed. In fact, the committee, as the CJ is aware about that. The members of the Supreme Court are aware about that. Everything is being done to complete those within a very short time.
There's been argument that, in fact, election matters should not go past the Court of Appeal. And only the presidential issues should go to the Supreme Court. Is there any thinking around that at the moment, to avoid this stretched period, when in fact they should have been concluded within 6 to 8 months?
Well, there is really no express provision for matters of election petitions to go to the Supreme Court. But if you look at Article 163, that establishes the Supreme Court and gives its jurisdiction, the Supreme Court has jurisdiction to deal with all constitutional issues that arise. Some of the petitioners or appellants went to the Supreme Court under that provision, and they managed to convince the Supreme Court to hear them. So that's how they ended up there.
And because of that, there has arisen quite a bit of dispute about the jurisprudence of the Court of Appeal and the Supreme Court, and some of it is very caused a bit of friction. What would you say about it?
I don't think really that it is friction. It is not really friction. I sit in the Court of Appeal. I sat in quite a number of those petitions. So when you are overruled, you bow to the High Court, because if you are also overruling somebody else, you have got to bow to that. So there is really no friction. There is no friction.
So if you've been working, as your mandate says, to deliver prompt and quality electoral justice that inspires public justice, and you have reviewed past elections in Kenya, and you say that there are lessons we can learn, what did your review find, and what lessons are you giving us going forward?
What we did after the 6 months, after completing the election petitions in 6 months, completing the election appeals in another 6 months.
And this is about 188
petitions in total. We brought together all the judges of the High Court, judges of the Court of Appeal, judges of the Supreme Court, and the magistrates who had the election petitions. The thinking of the committee was, let's get the judicial officers who handled these petitions to tell us the challenges they faced, and to tell us the gain, or to record the gains that we have made, so that come 2017 we don't repeat the same mistakes that we made during that period. So we brought them together, and quite very useful information was received.
Such as what?
Such as there were recommendations, not only from the Supreme Court, by the way, but even from all the other courts, and even the other stakeholders. We brought together even the LSK, the IEBC and others, and they came up with recommendations. One of the major recommendations was to extend the period for the determination of the presidential election petition.
Which is heard only by the Supreme Court?
Yes, which is heard only by the Supreme Court, from 14 days to 30 days. That's a recommendation which is before Parliament for consideration.
Anything else? Any other pertinent?
Yes, there are other recommendations that have been made. One of which, the major one, is also to amend Article 88 of the Constitution to give the political parties dispute tribunal exclusive jurisdiction to deal with the issues of party nomination. These are the ones arising mainly from party primaries. There is overlapping jurisdiction. If you look at section 40 of
between yourselves, the IBC.
No, not between ourselves. Between IBC and the political parties tribunal. If you look at section 40, it gives the tribunal that jurisdiction, and at the same time it is with the IBC. That was creating a little of a problem, and the recommendation was, of course, not unanimous with all the stakeholders, that the constitution be amended so that the political parties tribunal deals with those. And IBC, you know, once there are nominations from the parties, there are things like party lists where you have got to comply with the gender balance.
Yeah.
Persons with disabilities have got to be taken into account. IBC is supposed to look at those lists and tell the parties, look, you have not complied with the Constitution in this and that and that, Article 90, Article 97 and 98, and 177. So that is one of the recommendations.
Let me bring you to a matter that was you handled, which also exposes the discordance in the law. In the case, for example, of a petition being heard by the High Court, and an appeal arises out of that, such as happened in the Wetangula case, the by-election is supposed to be held within 90 days, yet the period of appeal can actually stretch past that time. So if somebody is appealing against the finding of the petition court, as happened in this case, and the petition is held in the period during which the appeal is still pending before the Court of Appeal, what happens? Has that been addressed?
That's one of the issues we wanted to address, because you see, we got views from IBC saying, look, time starts to run, and unless you complete the appeal within that period, IBC is bound to comply with the Constitution.
Yeah.
So that one is also being addressed so that it is harmonized and you don't get. In fact, one of the other recommendations that has been made by IBC and quite a number of stakeholders is that once you file an appeal against the decision of the trial court, there should be what we call automatic stay of the by-election. Yes. The by-election should not be, the time should not start to run for the by-election. The reason or the rationale behind that is that the IBC incurs huge expenses. Yeah. Then there are applications made to court, and depending on how the parties convince the court orders a stay, by which time IBC has spent hundreds of millions. Yeah. So the other recommendation to Parliament is that there be a stay, automatic stay of a by-election until the appeal is disposed of. Of course, we are aware that this can be abused.
It can occasion injustice.
Exactly. It can be abused because the incumbent will want, of course, the matter to stretch as long as possible. But that one is also, once that one order, that amendment is made, the courts are sensitive to that. We will deal with the petition appeals.
Is it possible to cap a time limit within which the appeal must be heard?
Yes. One of the recommendations we are making is that in a situation like that one, that appeal should be given priority over all other appeals, so that it is dealt with within a very short time.
Right.
Yes.
The reason why you decided to move the presidential petition from 14 days to 30 is because the last time there was some evidence which could not be dealt with, which the bulk of the petition by the court.
Yes.
Is that the reason? And is that going to be dealt with in that days?
Partly, yes. That is, if you read the Supreme Court judgment in the Raila petition, is that there was really no time. There was no time for the court to allow that amendment to be made, because that will require time to be given to the respondents also to respond. And that's one of the reasons the Supreme Court gave. So taking all those factors, and again, of course, once the hearing is complete, to write a judgment that is going to be precedent, a precedent-setting judgment, not only in Kenya but in very many other jurisdictions. You need time. You need time to write that. That's what is informing the recommendation.
Okay, so part of your strategic planning has been, thinking into next year, and you're working to instill public confidence.
Yes.
But this comes at a time of declining public confidence in the judiciary. Would you agree with that assessment?
Yes, there's some declining in public confidence. But sometimes, the judiciary is not considered in its totality. The judiciary has done a lot and is doing a lot of work. If you look at where we were in the late 90s, and where we are now, I mean, let's be honest, the judiciary has made great strides. The kind of work being done, I sit in the Court of Appeal. It used to take 6 months before the Court of Appeal could go to Kisumu, simply because of the numbers. You can't blame the judges who were sitting at that time, because they were very few. They were very few, and they were serving the whole country. The judiciary has increased the number of judges of the Court of Appeal. And in line with the devolution, the judiciary has devolved actually the Court of Appeal. Now the Court of Appeal sits in Nairobi, Mombasa, Malindi, Nyeri and Kisumu, taking services to the people. So, if you go to the statistics and see the rate of clearance of the cases is quite high. So the judiciary has done quite a lot. In spite of a few allegations that may be there, I think we are doing very well, and maybe the public is not. They need more.
I don't know. There is few. If you look at the judgment of the vetting board, the one in the newspaper today, they're saying the amount of corruption in the judiciary is huge, and in particular because of those allegations about corruption in petitions. In fact, some people are arguing that even that Supreme Court judgment of the presidential election was probably could have been banned by corruption. So how do we regain that now? Because it is about, in fact, many lawyers who have come to this show, they say even the vetted judge, the judges that were not vetted, who came after the Constitution, they are the ones that are most corrupt. So how do we now sort out that mess?
I don't want to talk about the allegations of corruption in the Supreme Court, because that is a live issue. A live issue.
I understand that.
But the other allegations of corruption in other courts, there are allegations. When the allegations are brought to the Judicial Service Commission, the Judicial Service Commission investigates them. Some they dismiss because they find they have no basis. Those that have a basis, there is a mechanism that is being employed and dealing with them. So the judiciary is not denying, or I don't understand the judiciary as denying that there is no corruption. But what is there is that all those issues are being addressed.
But how does this then impact on your work? Because if you're saying that you're going to be a credible arbiter of elections next year, and your public confidence is waning, your judgments are questioned, people think that the judges hearing the petitions, the disputes, are unqualified or biased or corrupt, how then do you become the final arbiter?
Unqualified how? Because you see, the vetting was over. The vetting was over. The judges who are now there have been certified to continue working. I'm one of them. So and we are doing our work. So as to how our judgments are rated, if somebody is dissatisfied with my judgment, you have the right of appeal. You have the right of appeal. So you know. the judiciary work is such that one party has to lose and another one has to win. It's very rare. You don't get, unless there is some kind of arbitration, you don't get like a draw. A
win-win situation.
A win-win situation, unless there is some arbitration.
We had a long-term clamor for the Supreme Court.
Yes.
But sorry, let's just finish with the elections before you get into the Supreme Court.
I was looking at the structure.
Let's finish with the elections because that's your substantive role and the reason why you're here. And we touched on some of the weaknesses. David, you talked about the appeals. And that wasn't envisaged in the law. But there are other weaknesses, aren't there? You lack the resources, you lack the physical space, and you're also concerned about the politicization, given that this is Kenya and everything is political, of your attempts to mediate this. This is coming out of your strategic planning. How are you addressing these weaknesses?
Thank you. In fact, I'm happy that you have asked that question. That is one of the major tasks that the committee has. Last time, when we were preparing for the hearing of petitions, we looked at the infrastructure. You know, petitions attract a large number of people who want to attend to hear the hearing. I mean, to listen to the hearing of the petition. You need space in courtrooms. We have a huge problem with that. That's one of the things that the judiciary is taking, and that brings me to the issue of the funding that the judiciary is given. Last financial year, the judiciary was given 16 billion shillings. Not many people know that out of that 16 billion, 8 billion goes to pay salaries, 6 goes to operations. That leaves about 2 billion shillings for development. It will take quite a while to be able to have enough infrastructure for the courts to operate optimally. So that's one of the issues that we are addressing of court infrastructure.
How are you addressing speedy justice in electoral petitions and not occasioning a backlog in other areas? Yes,
that is a big challenge. That is a big challenge we have because of the numbers. You know, we have an establishment. The High Court Administration Act was passed recently, which sets the establishment of the High Court at 200 judges, but we don't have 200 judges yet. So during the hearing of the election petitions, because this is a time-bound litigation, I want to plead to the Kenyans to understand that these are the same judges who have to hear these petitions. Until there are enough resources to employ enough judges to deal with petitions and deal with the other cases at the same time, the Kenyans have to be prepared to have some inconvenience in some of those cases. There are, of course, very urgent matters that have to be addressed. If somebody's property is being sold by, say, a bank or an auctioneer, you're not going to tell him that you wait until I finish the election petition. We take that into account. We don't take all the judges to go and deal with the election petitions. At least we have some left behind to deal with very urgent matters that have to be addressed during that period.
In fact, talking about that urgency of matters, there are people who get surprised in this country. Some matters come before court, they are adjudicated and finished quickly, and the others who live there, especially matters which have got political considerations. What is the criteria that is applied in prioritizing matters really? Is there a standard procedure?
The procedure really ideally should be first in, first out. But there are so many factors that go into deciding the cases. There are some people who file cases and they go to sleep. There are others who file the cases and they put pressure and those cases are hard. I'm not saying...
And what do you mean by putting pressure? How do I put pressure?
No. I mean, it's not really putting pressure. They come and say, look, we have to attend to this matter because of this and that reason and so forth. And when the court looks at its diary and realizes that it can accommodate. First of all, I mean, isn't that our duty to hear the cases as soon as we can? So if you have time, we hear that. So it's really not giving priority. It depends on the circumstances.
But also the lawyers themselves.
Yes.
They do what is called lawyering, which means if they don't want the case to be heard, instead of putting pressure, they delay. They come with all kinds of excuses so that the case is delayed indefinitely.
Yes, that is one other issue the judiciary is addressing very firmly. Because you know the buck stops with the judiciary. The public are told, look, this case was filed in 2000 and it has not been heard. They don't know what is in the record. The lawyers have come, they have applied for adjournment. Some cases I mean, you can't avoid granting an adjournment. Yesterday, we were hearing an appeal in Kisumu, and a lawyer comes and says, my client died 5 days ago. When you have a party who has died, there is a procedure of substitution. You can't go on, a deceased person cannot go on with the case. So those kind of things are there, and the public don't get to know what causes the delays. But the delays that are occasioned by lawyers, the courts are now addressing that very firmly. When you realize that the lawyers are maybe not ready and that's why they are doing that, we reject those applications.
Okay, so we have to take a break now. David, we'll come back to your question about the Supreme Court after this. This is Cheche. We're live on Citizen TV. Our SMS number is 22422, or you can tweet us using the hashtag. We're discussing the judiciary and elections. Tell us what you think should be done ahead of the general elections to ensure that the judiciary is seen as a credible adjudicator.